against very little evidence, and it's very hard. You hear this all the time to disprove a negative.
Go ahead and state your appearances.
Good morning, Your Honor. Kemp for Plaintiffs. Good morning, Your Honor. Eric Pepperman, Plaintiffs. Good morning, Your Honor. Tyler Watson for Affinity Lifestyles, Real Water.
Good morning.
Good morning, Your Honor. Dan Polsenberg for ETT1 doing business as Terrible Herbst.
Good morning, Your Honor. Oh, I apologize, Your Honor.
Go ahead,
This is
Mr.
Teddy
Parker.
Oh, thank you so much, Mr. Dodrill. Good morning, Your Honor. Teddy Parker, also on behalf of the plaintiff.
Good morning.
Good morning, Your Honor. Colt, Dodrill, counsel for Nevada Beverage.
Good morning. Guess that's it on Zoom. Okay.
Good sign.
Hopefully. All right.
And I said it, you didn't.
So we've got you set for the 20th through the 6th still, is that right?
Yes, Your Honor.
Exhibits, I think, is probably the first question in terms of where are we at with the
Your Honor, our final pretrial disclosures are being served on Monday, I believe. The exhibits will be electronic and submitted. We have the email from your clerk advising of the requirements, and I've instructed my staff to start preparing the hard drive with the electronic exhibits, and will be submitted in accordance with those requirements.
okay. I know we have something at 9, but in terms of the trial, any issues, questions, concerns, definitely be bringing, well, and we have a hearing or two coming up, right?
Yes, sir.
But I guess let's stick with trial. Any issues, questions, concerns with anything trial related?
Nothing from plaintiffs, Your Honor.
Nothing for Real Water, Your Honor.
And Plaintiffs is coming by, having someone come by and pick them up today. So those will be distributed.
Okay, so jury questionnaires finished yesterday. Someone's gonna come pick them up, you said today,
We'll plan as, yeah, Holo, I think.
and then they'll be distributed to everybody. Bear with me, let me pull your case up here too. You know, there's a lot of motions when I have to scroll the mouse multiple times to get through just one day of the calendar on January 5. We probably want to right now talk about hearing scheduling. And we may also have to talk about that at 9 after the other calendar calls. But probably fair to say we can't do 100 or whatever motions on the 5th. Everybody agree with at least that?
Yes, Your Honor.
Yes, Your Honor.
Yeah. Yeah, and some will depend on what happens with the other trials on this stack, and hopefully we'll know a little more when we call you back at 9, I guess. Just looking at my January calendar a little more. At least right now, the 12th and the 14th, because I don't know, we did a bunch in some of the afternoons last time, is that right? Yeah. Yeah, so that we'll see if I have any afternoons free before we start. If not, we'll probably have to divide, between 5, 7, 12, and 14 in the mornings. When do we need the electronic exhibits?
I believe for them, their deadline, they needed to be completed by January 6th.
Okay. Any issues with January 6th for the electronic exhibits?
I don't believe so, Your Honor. If something comes up, we will inform the court, but I think that shouldn't be a problem.
Ben's side okay with that too?
Yes, Your Honor.
Okay. All right. So I think we're pretty set other than at 9 after we do the other calendar calls. Candidly, I'm not super hopeful I'll have a lot of time before your trial.
Yeah, on the 9 o'clock, we have an appearance in the Gallagher case at 9 o'clock with Judge Williams. I was wondering if you could give us a hard time maybe later. Thanks.
How much do we have? Yeah, it depends on I don't have a whole lot at 9.
Judge Williams is pretty light too, so I can go up there and ask him to.
Yeah, whichever.
Judge Williams is not big on taking things out of order.
That's fine. So go
Okay,
up.
cool.
Oh, okay. Yeah, go up there then. That's fine by me. I'm not in trial today, so
Maybe do a hard stat at 10 down here.
10, yeah, and hopefully definitely not before 10 and maybe a little after that, but yeah, that's does that work on the defense side?
Yes, Your Honor.
Okay.
Well, Will knows I've got somebody who's trying to schedule something for me at noon.
Oh, we should be done before then.
I've heard that in this case.
If
you have anything to say.
I should be a little cautious, but yes, if I have anything to, yes, we, yeah.
At
I
the very least, if we took a break.
Yeah, for sure. I also have noon all judges meeting at noon, so.
Excellent.
We all have hopefully good motivation to be done before then.
Just in the 2 things I have on my list for coming back at 10 is the motion for summary judgment on the judicial estoppel. I talked to Mr. Watson and we don't see why that can't be kicked. And then the motion for summary judgment on partial summary judgment on the statute.
On the statute, okay,
Right.
good.
Yeah.
Okay. Yeah, let's plan on arguing the statute of limitations motion. Certainly first, estoppel if we need to and or get to it. Okay. I'll see you in an hour plus.
Thank you very much.
Okay,
Your Honor.
thank you. Thank you. I guess go ahead and state your appearances again.
Morning again, Your Honor.
Karen Bashor on behalf of Nevada Beverage.
Tyler Watson for Real Water.
Jim Cavanaugh for ETT1 DBA Terrible Herbst.
And Dan Polsenberg for ETT1 doing business at Terrible Herbst.
Colt, Dodrill, bar 9000, counsel for Nevada Beverage on Zoom, Your Honor. Good morning.
Good morning, good morning. Okay, so correct me if I'm wrong, but off the record, I think hearing schedule was pretty much worked out. Is that fair? So January 5 p.m. what
I think
time?
we
Like
have it.
1:30?
Well, yeah, whatever you decide, but.
Does 1:30 work for the afternoon one start?
Fine, Your Honor.
Yes, Your Honor.
Okay, so January 5, 1:30.
AM for morning. See, they were coming at I told them 10 o'clock because 9 o'clock,
Okay,
you can handle whatever.
January 7, 10 a.m. January 12, 1:30 p.m. January 13, 1:30 p.m. January 4, 1:30 p.m. And then you all are gonna send us like the list that, hey, these on this day and these on that day, is that right?
Is your
Yes, Your Honor.
Yes, Your
By
Honor.
Monday at noon.
Monday at noon.
Monday, okay. Any other issues before we move on to an actual motion? Okay. So. The plaintiff's motion for partial summary judgment on statute of limitations, defense. Okay, so I've reviewed that, opposition counter motion. Joinder, opposition, 2 binders worth essentially, I think, but well, I'm inclined to grant plaintiff's motion for partial summary judgment on statute of limitations, defense deny the counter motion or motions. I think plaintiff's reply is pretty succinct on the reasoning why. I kind of probably hinted at this when we talked about the statute before. But welcome arguments. Oh yeah, let's talk about time before we do that though, to be clearer than I was before. Backing up a little after this one, do we still need to argue the judicial estoppel motion would be my first question, I guess.
Mr. Watson and I were of the view that we could continue that to January 5th.
That's correct, Your Honor.
Okay. So the stop will move to January 5th. And Ms. Rivera left, is the 5th one of our AM or PM days?
PM, Your Honor.
PM, okay, so that one will be January 5, 1:30 PM. Okay, so all we have then is this statute of limitations motion today.
And Judge, in light of the court's inclination, I'll reserve my time for rebuttal.
Okay. So I do have some time, so if you all want to take 20 minutes in opposition, half an hour even, if you really want. Total, divided amongst whomever wants to talk, I understand.
For ETT 1, I prefer to defer our time to our co-defendant.
Okay.
We have a joint opposition, so I would like to give our 20 minutes to Nevada Beverage on behalf of ETT 1.
So what I'm saying, to be clear, let's say half an hour total amongst whomever on the defense side. Yeah, you're welcome to give time to whomever.
Thank you, Your Honor. Colt Dodrill, counsel for Nevada Beverage, bar number 9,000. I don't think it will take that long. What I think gets lost in the shuffle, and what our friends were ignoring sort of in their briefs, were the canons of construction. And Justice Felix Frankfurter told us the 3 rules of statutory construction are read the statute, read the statute, read the statute. And we've looked at it, and what we did not see was language that upon death of an injured person, a new time period accrued. And what the plaintiffs want to do in this case is ask the court to pull out a red pen and cross out the words "or death" in NRS 11-194E. And of course, they can't do that because the statute of constructions prevent us from rendering any section nugatory or superfluous.
So
We
I agree with you in terms of, the first rule of statutory construction is certainly read the statute itself. Where I think I run into and you're probably going to talk about this, but just in case. So if you're looking at 11.190 4E within 2 years, and the first clause doesn't apply, I don't think, but so within 2 years in action to recover damages or injuries to a person or the death of a person caused by the wrongful act or neglect of another. So if we're talking about wrongful death, how is it not within 2 years after the death? That's where I really struggle with understanding your argument there.
Great question, Your Honor, and it does go back to reading the statute and the plain language, which is paramount. And if the clock, we'll talk in terms of a clock, when does it start ticking? And it starts ticking upon the injury. And in some states, and we provided, Your Honor, in our briefs, we looked to sister jurisdictions that had specific language, and that's Arizona and New Mexico. And those states had specific language in their statutes that said, in cases of wrongful death, the time accrues upon the death of the decedent. And that's in the Arizona statute, and that's in the New Mexico statute. The Nevada statute does not say that. So if you read it plainly, that clock starts upon the injury, in this case, Mr. Herbst's liver injury in 2016, and a new clock does not start running upon his death. And to understand that, you look at the Massey case, which was only interpreting NRS 41A097. And what that case said is that statute at the time only said injury. And it read into the statute, well, in a wrongful death case, the death is the injury to the heirs. And it looked to the Utah Supreme Court case, which said, and that's FOIL, which said, in a wrongful death med-mal case, we do not want to encourage premature suits, meaning suits before they died, because people will file meritless cases prematurely because they're not healing as well, as fast as they would like, and they're not feeling as good as they would like. And it clogs the court, and it provides an incentive for what the FOIL case said would be unscrupulous doctors misleading their patients to below the statute of limitations. And we do not have that language in 11-194E. It says injury or death. And we know from the canons of construction that we can't cross out or death, which is what I said, which triggered Your Honor's question. We also know that the term or is disjunctive. So injury is distinct from death in 11-194E, and that's what our legislature said. Our legislature knows how they could have written it, and they wrote it that way, which is different than NRS 41A097. And as the court will recall, we did not always have 41A097. The legislature crafted a specific statute for a specific purpose that the Massey court told us had a specific public policy consideration not to promote early litigation. So think of it as in medical malpractice, we want them to file suit later so we're not clogging the courts with people that are just taking longer to heal. Conversely, in NRS 11-194E, we have injury or death. So injury is distinct from death outside of medical malpractice cases. We also have a different public policy, which is a case we cite, the Jamison Family Partnership, which states we want to promote early litigation. So folks are filing suit timely while evidence is around to promote repose, and that gives security and stability to human affairs. And that's 106 Nevada 92. That's cited on page 12 of our counter motion. And so you have this big distinction. You have 41A, which says one thing, and 11-190, which says another. 41A wants folks to file suits in to file medical malpractice suits later, whereas 11-190 cases, the Jamison Family Partnership case, wants us to file them sooner. And the legislature knew this. And so that's why the 11-190 has different language. If the legislature wanted the same result, it would have used the same language, and in fact could have used the same statute, which they had for years until they turned 41A097 live. So there's different statutes with a different purpose. And the other public policy consideration, the other canon of construction, is to avoid absurd results. And I can't imagine, Your Honor, having a lawsuit that's a wrongful death where someone says, my dad died of a TBA from an auto accident 20 years earlier. He had just found out that the person that caused that accident just got out of prison for a DUI. Had he known that, he would have filed suit. But since he just died, I can file suit now. I believe Your Honor would have thrown that case out quickly. This case is really on all fours with that. You have Mr. Herbst being sick for 8 years before he dies, and they file suit 3 years after the recall. That violates the Jamison family case because a lot of the evidence has waned. And you saw that 2 weeks ago when we argued the causation argument and how much evidence was gone. So this is really starting at the top of the canons of construction with plain language. And I am not as well versed as Shane is, but I do have a chart. I'm happy to put that up if the court will indulge. I have sent a sharing request. And I think it helps simplify that. And so I'm gonna share a simple screen. If the court can see that.
Okay.
And it's really specific versus general.
Can you it is up there, but maybe if you can zoom in from back that. Okay, I can, if I look on my monitor up here, I can read it. Okay.
And a version of this, I believe, is in our reply. I did tweak this a bit so it would show up better on this, but you have a specific medical malpractice statute, and you have a general NRS 11-194E. The court has ruled that 41A accrues upon legal injury. We have 11-190, it accrues upon legal injury or death. That's different language. The key is the third row. A later accrual time based on public policy concerns, yes, on a medical malpractice statute case. No, outside of that, under the general 11-194E case. And we have Massey, NRS 41A097, statute of limitation time resets upon death. In 41A097, you get a new clock running. That does not occur in 11-194E. So you got different statutes serving a different purpose, with entirely different language, applying in the world of completely distinct public policies. That's why it's 2 years from injury. And injury does not mean death in this case. Massey and its progeny, which includes Pope that my friends had cited in their moving papers, does not apply outside of 41A. And since there's no genuine issue of material fact, it's not a medical malpractice case. The language is different between the two statutes. And if the court has questions on the statutory construction, I'm happy to answer those. Otherwise, I'm prepared to move into why the discovery rule does not extend their date beyond where we have it.
Oh, sure, you can go ahead.
Thank you, Your Honor. So there's no discovery rule applicable to the plaintiffs for 3 reasons. One, they've not produced any evidence of diligence. So there's no genuine issue of material fact that Milo Herbst was not diligent in investigating alternative causes of his injuries, which of course the Adkins case says is required. Diligence suggests activity, active. You see that in your business court cases, due diligence. It's not passive. Sometimes, and at least they argue it, correct? And what we didn't see here is any activity by Milo. What we saw was passiveness. And if you'll remember 2 weeks ago at the causation argument, there was a lot of discussion on both sides of the newspaper and the 2024 newspaper with the pink highlighting and what does that mean?
Yes.
Yeah. Thank you, Your Honor. And I tried to make that very memorable. And it comes back here in the terms of the statute of limitation. It's not probative as to what Milo knew or should have known in 2021. It's certainly not material. And as we argued, it seemed that it wasn't genuine because anybody could scribble anything on something later. We would have wanted something more contemporaneous with his consumption or contemporaneous with the triggering event, which was the recall. And so whether you look at it as unclean hands or latches, the court in July, when we were before Your Honor last on the statute of limitations, found that there were issues of fact as to whether Nevada Beverage was prejudiced by the delay. And then I refer Your Honor again back to the causation arguments. Again, this dearth of information. We now know it's been confirmed Milo Herbst owned Spring Valley Market. And we know that the manager that they claim would have given him the real water or rang up his cash purchases. We still don't know what that is. Her name's Mary Lou, and unfortunately she passed away. And you saw the Costco records we had put on the screen for the causation argument. Costco records only went back 2015. Terrible Herbst records only go back to 2019. Spring Valley Markets records don't exist as to that. So none of those had been preserved. We would have hoped that knowing that Milo Herbst believed he drank real water, that Milo Herbst believed that real water was the cause of his injuries, and Milo Herbst believed he obtained it from Spring Valley Market, that those records would have been preserved, and as well his testimony would have been preserved. But what we didn't see was a Rule 27 deposition to give us the opportunity to hear from Mr. Herbst himself. And whatever he knew or didn't know or drank or didn't drink died with him. And we think that really prejudiced us. And so whether you look at it from an unclean hands or a latches, you get to the same point, which is Mr. Herbst and the plaintiffs didn't take the right steps ahead of time. And in this lawsuit filed 3 years after the recall, really has disabled us. And we're struggling to defend a case. Your Honor, did not grant our counter motion on causation. And we are forced to defend a case with against very little evidence. And it's very hard. You hear this all the time to disprove a negative. We're trying to go up against what we argued was hearsay, speculation, whimsy. And it's very hard to find concrete evidence to disprove that. And so while the court found issues of fact in July, discovery has shown that that is not an issue anymore, that we are indeed prejudiced. And even if the court follows or finds that the discovery rule would apply in this case, we have to look not to when Mr. Herbst found a 2024 newspaper, but when he knew or should have known. And that's really what the heart of the Adkins case. Should he have known? And Your Honor found that it was speculative in July for us to suggest that Milo Herbst had imputed knowledge of the recall based on his ownership of Spring Valley Market. So we directed a lot of discovery, and we had the opportunity to depose Tevis Herbst. You saw some of her testimony 2 weeks ago. She agreed that her dad had owned Spring Valley Market. And in fact, Mrs. Herbst, as her role as administrator of his estate, owned it at the time we deposed her. So that's no longer a factual issue. We also had the opportunity to depose the bookkeeper, Charmaine Ferrari, and she confirmed that Milo Herbst owned Spring Valley Market. We also deposed various folks, including Nevada Beverage salesperson Kenneth Lai, who knows that he picked up the product and that Mary Lou had already pulled it off the shelves. So Mary Lou, the store manager, knew about the recall, had pulled the product off the shelves in anticipation of Nevada Beverage picking it up. Kenneth Lai picked up the loose bottles, issued a store credit to Spring Valley Market, which means we were basically buying Milo Herbst's real water back and crediting his store. And then a few days later, truck driver Edward Molina showed up at the store, picked up the full case, which Kenneth Lai had marked on it, do not put out for sale, pick up. And he picked that up and issued another credit. So Milo Herbst received 2 credits for the product. The product was off his shelf, and under the Strobehecker case, he's imputed with the knowledge of his agent, in this case, Mary Lou, who knew about the recall. And what makes this interesting is this is a hair club for men situation. Milo Herbst wasn't just the president of the company, he was also a client. And if Milo Herbst drank as much real water as our friends would want us to believe, then he would have known about the recall. And I can provide the court 3 quick examples. The big one is in the 80s when Tylenol came off the market, when it was tampered in Chicago and some people died from the product being laced with cyanide. Anybody going to the store nationwide to buy Tylenol would have seen it's not on the shelf. And somebody that was suffering from illness would have the inquiry notice to ask, hey, where is the Tylenol? Other examples, one is Blue Pepsi, which came and went while I was in law school. And while I'm not aware of any injuries it caused, anybody that wanted to buy their favorite Blue Pepsi would know when they can no longer find it in the store or vending machine. And the same thing with the square Downy Flake waffles that I enjoyed as a kid. As an adult, they became Hungry Jack. And now I'm a lawyer, they're not available at all. And the only waffles in the freezer section are round. Unfortunately, I haven't gotten sick from them, and I don't know if anybody did. But if it's your favorite product, and if it's the only thing you've drank, you would notice when it's missing. And that is clear inquiry notice. And I'll end with the diligence again, had he done it, because he's charged with what he would have found out, whether he did it or not under Atkins. And had he done that, he would have seen the incredible volume of media that was around. And that includes the FDA press release, the CDC release, the Southern Nevada Health District release, Brent Jones' public apology, news about all of that, including the Review Journal, which carried it heavily, including running photographs of Mr. Hunwards in his hospital gown. And that was just a lot. So had he searched real water, liver injury, or liver injuries in Las Vegas, Mr. Herbst would have been alerted. And the Atkins case says he had to be active and he had to do that. So even if he did, and again, we don't think he did because they didn't produce anything, he would have had actual notice. He would have been put on inquiry notice or constructive notice, or he would have known. So either way, he's charged with that. And so if we look at an illness from 2016 and give him the benefit of the doubt of the discovery rule, that would be March of 2021. 2-year statute from that injury would have run and expired in March of 2023. And even if you fudge it a few months here and there, because maybe it would take him some time to search it, that would put him out middle of 2023. And even if you give him the end of 2023, this lawsuit was not filed until February of 2025, making it late by any measure. And I know it starts with the statutory construction, so I wanted to walk Your Honor through that. And then from there, Atkins tells us how we apply the discovery rule. And this case is extremely late, and we would ask that you grant our counter motion for summary judgment.
Thank you very much. Any rebuttal?
Yes, Your Honor.
Or I guess before, sorry. Did I miss anybody on the defense side?
No, Real Water joins in the argument presented, has nothing else to add.
Okay.
Thank you, Your Honor.
Thank you.
Your Honor, starting off with some generalities, statute of limitations, it's a defense. The burden of proof is on them. They seem to forget that. But let's start. First off, our motion is based on 2 independent grounds. The first ground is the language in the statute. And then the second ground is the undisputed facts as to the date of the actual notice and their failure to have any facts of actual notice prior to this June of 2024 time period. So let's start with the statute. The court ruled earlier that the wrongful death claims accrue upon death. Shane, can I have the reply to 10 through 16? Judge, these are the comments you made at the previous hearing. Your interpretation of the plain language doesn't begin until the accrual, 2-year doesn't begin until the death. That's what you said then, and that's your general inclination now. And I think if you take a look at the plain language of the statute, that should be the result here. Now their biggest argument is that this rule is limited to medical malpractice cases. On the chart Mr. Dodrill showed, he said it was specific to medical malpractice cases. Well, first of all, the rule is in Pope versus Gray. Yes, that's a medical malpractice case. Pope said, quote, the very earliest that the statute of limitations would begin to run for wrongful death action would be at death and not before, unquote. That's the rule. That's in Pope. That's in Galloon. That's in Fernandez. So they say, oh, medical mal cases with doctors, that's different. Well, that's not what the Supreme Court said. If you take a look at Atkins, that's our latest case on the discovery rule. Atkins specifically cites 2 Nevada Supreme Court medical malpractice cases in support of its decision. They don't cite Pope or Galloon, but they are basing this decision on medical malpractice cases. So the Supreme Court has rejected this notion that there's some special rule for malpractice cases as opposed to other cases. And let's take a look at the public policy. Their public policy argument, when you really boil it down to its essence, their public policy argument is that you should have a longer time to sue doctors than drunk drivers. That's their public policy argument. And I don't see any basis for that kind of claim. You know, my father was a doctor. He'd be appalled if I suggested that there was a public policy that there should be a longer time period to sue physicians as opposed to other people. And that's why the Supreme Court has used these medical malpractice cases in support of its opinion in other areas. Remember, Atkins was a toxic tort, similar to what we have here. So for those reasons, Your Honor, we think your initial inclination and the initial comments you made at the hearing are correct. That the 2 years starts upon death. It's a simple rule. It's a bright line rule. You know, there's good reason to treat death different than other things because it's.
So if I continue with my inclination on that first point in terms of the plain, unambiguous statutory language, that the cause of action accrues upon death. Do I even need to get into the discovery rule or equitable tolling or any of those?
No, Your Honor, that's an alternative ground, and that is our second alternative ground for the motion for partial summary judgment. So let me address that. So let's start with the undisputed facts. When we were here the first time, the only thing we had was the June 17th email that said, "I just found out." Shane, can I have that? That's in the reply on page 21 lines 30. Okay. So this is the email we had last time. He just found out. And again, the date of this is important because if court remembers the Wren verdict came on June 14th, 2024. There was an article in the online edition about an hour and a half or 2 hours before this email was written about the Wren case. And that article included reference to the Gallagher $28 million compensatory verdict. So that is obviously what is being discussed here. So since the initial hearing we had on this, we took the deposition of Riley Miller. Riley was a handyman that did a lot of work for Mr. Herbst. Riley testified that he had a conversation with Mr. Herbst that night, June 17th, about real water. And that as a result of that conversation, when he went to the convenience store the next day, which would be
Purchase the paper.
he bought the newspaper. So this solves another mystery. Where did this newspaper that Mr. Herbst had come from? Can I have Riley's? So Riley sends an email, or excuse me, a text on June 18th to Milo. Shane, that would be the reply 2211 through 12. Page 2211 through 12. So this is his testimony that's leading up to the text. And I think the text, Shane, can I have that? And are you in the reply? Where are you at?
I think so.
Okay, got that. All right, there's the text. And we took this off the cell phone that the defendants demanded. We produced his cell phone, and amazingly, we figured out the password. And it was amazing, but because the family didn't have it. But anyway, so we gave them these texts, and the text says, "I left a newspaper on your kitchen counter. There's an article you might be interested in." This is the date of actual notice. He responds, and the response is down on line 17 with another text back saying, "Very interesting." Okay, but there's more. Next, we remember, this is on June 18th. We go forward to the day of June 21st. Shane, can I have the picture of the newspaper? This is a picture of the newspaper. Okay, Mr. Dodrill mocks this evidence for some reason. I don't understand why, but this is Mr. Herbst's handwriting. Show to Dr. Redmond. And we know it's his handwriting because it was authenticated by Mr. Murphy, who was familiar with his, it was Mr. Murphy and Mr. Miller authenticated this. So show to Dr. Redmond. Who's Dr. Redmond? Dr. Redmond is his hepatologist that he had seen for the first time on June 14th, 2024. So he writes in here, show to Dr. Redmond. And there's more, Your Honor. The next thing that happens, next one, Shane, please. So this is a slide that's taken from a video. Mr. Murphy is one of these people who likes taking a lot of pictures and videos. So he took a video of Mr. Herbst walking into the emergency room. Mr. Herbst, he had 28 pounds of fluid on his stomach at the time. He needed a draining. So he's kind of shuffling up there. If you see in his right hand, we've blown that up. That is the same newspaper. So all this establishes unequivocally that the actual notice in this case was June 17th, 18th, 21st time period. So when we started this discussion, statute of limitations, the defendants took the position that they would be able to prove earlier actual notice than the email. And to that end, they did a number of things, one of which was they subpoenaed the RJ and they wanted the circulation records. They were trying to show that Mr. Herbst was a subscriber to the RJ, and that's how he got the newspaper. That failed miserably. They took depositions of a number of people, friends and family. None of them gave them any kind of evidence of actual notice. They produced voluminous medical records. I don't know how many we're up to, but it's tens of thousands. But there's no medical record talking about real water before this June 17th time. There's no friend or family member documenting earlier knowledge. There's no emails or texts. And again, I point out, we produced phone text of Milo Herbst that go back quite some time. And we also produce emails. Nothing. They went through all of them, nothing. So they have no evidence whatsoever as to actual knowledge. So what do they fall back on? They fall back on the exact same argument they made previously. He should have known. He should have seen the Southern Nevada Health District release. He should have been watching the TV more and seen TV news shows. He should have somehow or another got in the newspaper, even though he didn't subscribe. And then he should have done something. You know, first of all, let's contrast that with what the Real Water, who's joining this motion, says about Blaine Jones. If you remember, Blaine Jones went to the hospital with acute liver failure. He was told about 2 prior instances of acute liver failure. The vice president of sales begs him to do a recall, and yet he, according to Real Water, doesn't have sufficient information to associate Real Water with liver failure. That's the standard that's been set here. And so we would submit that that's an estoppel. But even if it isn't, there is no case law that supports this run to speculation. They cite securities law cases, which involve sophisticated purchasers. Their lead case is Blanton. It's a Kentucky case. That was about a chemical plant. That case required actual notice. That person filled out a questionnaire at the chemical plant about whether the chemicals caused him injury. So that was an actual notice case. Another case they cited, and I haven't heard anything about today, was Judge Gordon's case. He required actual notice. When you boil down all these cases, they require some kind of proof of actual notice. Instead, we got the same argument you heard before. He should have seen the YouTube video. He should have seen the press release. You know, he should have done something. And removal is a magic thing that should have, the product's not on the shelf anymore. So because it's not on the shelf, he should have known there was something wrong with it that could have caused his injury. Well, we cite the deposition of their employees. Mr. Molina, a truck driver for Nevada Beverage, he didn't know he was involved in the removal. Number one, he didn't know there was anything wrong with the product that could cause you health injuries. And number two, he didn't know what it was. The Terrible Herbst managers, we took both of them out there at the Boulder City store. Neither one of them knew anything about the problems with Real Water. These are the people that actually took it off the shelves. None of them knew that it hurt or injured people. None of them knew that there was a liver risk. That's their own employees. And so they're saying that Mr. Herbst should have had more knowledge than they had. And so for those reasons, Your Honor, we think that what it really boils down to is you have undisputed facts establishing the actual knowledge date, you know, the June 17th, 18th, 19th, 20, and you have no fact, not even one fact, a glimmer of a fact that suggests any sort of earlier knowledge. And then they come back with speculation. And the court comment on speculation before. Shane, can I have that, please?
This is why I try and choose my words carefully.
Okay, well, you know, Judge,
sometimes unsuccessfully.
you know, I lead a pretty shallow life. I go through these transcripts late at night. So reply 9 through 24, Shane, 9:24. You know, I don't want to bear shame.
I can also, I've got it.
Okay,
So
you've got it.
reply page 9, line 24.
Right.
Yeah, okay.
So that,
Quoting myself.
right, quoting yourself, this is what you said about speculation. And that sentiment was repeated in the order that was entered, which is referenced in that same section on page lines 27 through 28. And we think that's the appropriate position. And again, like I said before, all the cases require actual notice in a personal injury context. In an SEC context, they're taking a different approach, but those are sophisticated purchasers. big trading houses, sophisticated investors. It's not the same rule for consumers, and that's what the cases say. So with that, Your Honor, I'd submit it, unless you have any further questions.
No questions.
Thank you.
Thank you very much. So, yeah, the court sticks with its initial inclination.
Your Honor,
Oh,
I'm sorry, it was a counter motion. I thought I would have an opportunity to rebut.
okay, you have 10 minutes.
I can do it in less, Your Honor. Plaintiff is correct. I do have the burden of proof on the statute of limitations, which I meet. Simple math, 2025 minus 2021. Plaintiffs have the burden to show the diligence, and they've not met that burden. They may have evidence that may suspect when Mr. Herbst had actual knowledge. I don't have to prove he had actual knowledge. Under the Adkins case, which is my lead case, and a fresh case from the Nevada Supreme Court, they have to show the diligence and what he knew or should have known. And he has not shown the diligence. The text and the emails that they talked about don't show any diligence by Milo Herbst while he's suffering his injury, which started in 2016 and continued on. So from 21 through 2024 or 2023, when I argue the statute had concluded, they've not shown anything. So for them to say I have to prove actual notice is not true. And they've ignored the fact that they're saying he bought real water. They bought real water. He would know when he could not buy real water anymore. So that is something that's entirely ignored. And I'm a little confused with their evidence in their reply about all the stuff, all the witnesses that said he drank real water. If these witnesses said they drank real water, and we're going to believe that Mr. Herbst drank real water, he stopped drinking real water in March of 2021 when the rest of the world did, when it stopped being available to anybody. The reference to the Adkins case, also the fact that it's a toxic tort case, is immaterial. This is not a case where for 20 years we didn't know that there were carcinogens in our foot powder. This is something that once the FDA investigated was very public very quickly, including the Brent Jones. So this isn't a secret. And if we look at the facts of the Adkins case, which we addressed in our reply, those folks had filed suit more than 2 years after death. So the Adkins case does not talk about when the statute accrues for for a wrongful death case outside of medical malpractice. It talks about application of the discovery rule when a suit is otherwise time barred, which is this case that we have with Herbst. So Adkins supports us, and it tells us, hey, you need to exercise diligence. The discovery rule applies, and it does not adopt a medical malpractice policy outside of medical malpractice. Now, I'm a lawyer. I didn't write any of those decisions we cite. I didn't formulate the public policy. What we do does not change the fact that our legislature drafted 2 different statutes that our Supreme Court has interpreted one a certain way, and that our Supreme Court has told us there are 2 distinct public policies to follow, and that one only applies, and that's the Massey case adopting the Utah case, that we don't want early medical malpractice lawsuits being filed. But the Jamison Family Trust case exists. I didn't write it. The folks in Carson City did, and we're bound to follow that. And I would ask the court to interpret 11-194E to not restart the clock upon death of an injured person and find this case time barred. Thank you.
Thank you. So I'm still sticking with my initial inclination. I'm not going to read through out loud plaintiff's motion and reply, but touch on some of the highlights. We'll need a detailed order, findings, fact, conclusions, law, prepared by plaintiffs, submit to everybody on the other side for review and approval. In an ideal world, I would write this order myself, but it's not an ideal world. So in any event, there are no genuine issues of material fact. I further confirming, I guess, my quote from July 14 and the order that accompanied that. I mean, the defendant's position here is based on, and I may get this quote a little off, so double check it, but gossamer threads of whimsy, speculation, conjecture. To be clear, NRS 11.190.4E is controlling. The Adkins versus Union Pacific Railroad Company case is also controlling. I mean, I've been wrong before, but my read of 4E, the plain language, wholly supports plaintiff's position, and the opposite on defendant's side. I struggle to really understand defendant's position on that. And so that's the primary basis is, the cause of action accrues at death. The clock starts ticking, if you will, upon the death caused by the wrongful act or neglect of another. And clearly, if my read is correct, then this complaint's clearly timely filed. Alternatively, then you get into, and still the statute of limitations, affirmative defense, the burdens on the defendants, which they haven't met even under summary judgment standards. I do agree somewhat with defendants. I think plaintiff misreads, at least in part, the Adkins case. I agree with defendant in terms of if you do need to get into discovery rule tolling, the burden shifts to plaintiff on that. If you do need to get into equitable tolling, plaintiff has the burden on that as well. I agree with the Adkins controls. But even then there are, and this is an alternative reason, but there are no genuine issues of material fact. Plaintiff exercise reasonable diligence. I mean, again, whimsy, speculation, conjecture on the defendant's side, wholly rebutted by all of plaintiff's evidence. Adkins to me is much more informative and much more on point and controlling, obviously, than in the couple other older cases that plaintiff mentioned. But Massey, Adkins is much more on point here than Massey is, and I wish I had those other case names on the tip of my tongue, but I don't. But prepare a detailed order. Again, the plain unambiguous language of the statute controls alternatively. the discovery rules met. Anything else? Any questions? The counter motion's denied, to be clear, the joinders and the counter motion's denied. Not hearing anybody. We good? Thank you.
Thank you.
Thank you.
Next year.
Thanks, Your Honor.
Merry Christmas.
Happy New Year. Thank you. Thank you.